Courtside Commentary. We're here today to discuss 4 recent cases from the United States Supreme Court that impact the administrative state and therefore you. I'm pleased to be joined by 4 of my colleagues here at the New Civil Liberties Alliance to discuss these cases. John Vecchione will be discussing the McLaughlin Chiropractic Associates v. McKesson case. Cara Rollins will be discussing Diamond Alternative Energy v. EPA. Casey Norman will be discussing Martin v. United States. And Andy Morris will be discussing FDA v. RJ Reynolds Vapor Company. Let's get started. Andy, the FDA v. RJ Reynolds Vapor Company case, what was at issue here? What was the FDA trying to do?
Well, Mark, this case is about when individual citizens and small businesses who are injured by agency decisions have access to the courts to challenge those decisions. Here, this case was brought by a number of convenience stores and gas stations who sold certain e-cigarettes. The FDA decided that they had to take those e-cigarettes off the shelves. And if they failed to take them off the shelves, they could be fined and even conceivably sent to prison. The convenience stores and gas stations believed that under the law, they were permitted to sell these products, that they were safe to sell, and they disagreed with the FDA. They tried to take the FDA to court under a law that Congress passed that permitted anyone adversely affected by an FDA decision to go to court.
And they did this in Texas, if I remember correctly?
And they did this in Texas, where they're located in that region. They're in Texas and Mississippi, and so they sued in their local court. They filed jointly with RJ Reynolds, who's based in North Carolina, in one lawsuit, so that enabled RJ Reynolds to sue in Texas. The FDA didn't want RJ Reynolds to be able to join in that suit in Texas, so what it did was it took the position that none of these small businesses who were injured by this decision had a right even to sue.
So the case in front of the Supreme Court really boiled down to, can this case be brought in the Texas district courts and in the Fifth Circuit, or would it have to be brought elsewhere?
I'd boil it down a slightly different way, which is even more basic, which is, can these small businesses sue at all?
Okay.
And because of the concern that you correctly put your finger on, the FDA tried to get around that by saying, well, we think these small businesses, they shouldn't be permitted in court at all. Only the big guy who manufactures these e-cigarettes can sue.
Who was the person that the order from the FDA was directed against?
Correct. The FDA issued an order that said RJ Reynolds can't market these e-cigarettes that have been on the market.
And what did the Supreme Court decide in this case about who can sue?
The Supreme Court disagreed with the FDA and agreed with the small stores. It ruled to keep the courthouse doors open for anyone who was adversely affected by the FDA decision.
So why should people outside of this case care about it? It sounds like it's just sort of an internecine battle between the FDA and a sort of tobacco company.
They should care because the same problem isn't limited to the FDA and the companies it regulates. It applies to many, many agencies across the spectrum. There are, of course, many, many federal agencies. In this case, for example, we submitted an amicus brief to the Supreme Court where we explained that this same concept of permitting adversely affected companies and people to challenge agency decisions applies in more than 100 statutes. And the Supreme Court actually cited that in its decision, and that shows the very wide impact of this decision. It's a very important step in keeping the courthouse doors open for the many people that are affected by decisions made by the administrative state.
Oh, it's always terrific to see our amicus brief cited. Congratulations on that, Andy, and thank you for explaining this case so concisely and thoroughly to our audience.
My pleasure.
Casey, Martin v. United States, what was happening in this case?
Yeah, so it is quite a tale. This case really arose from an FBI SWAT team's wrong house raid of an innocent family's home. They were investigating a dangerous criminal involved in a drug circle. The petitioner in this case, Trina Martin, and her family at the time were fast asleep. They had no connection whatsoever to the FBI investigation. But what happened is the head FBI investigator who was leading the raid, he claims that his personal GPS led him both to the wrong house on the wrong street, and when he got there with the full team, he couldn't check the clearly marked house number out front because it was dark outside. Not sure about that excuse, but anyway, what happened is the team burst through the door. They broke it off its hinges. They filled the house with the explosions of flash grenades. They woke up this terrorized family who thought criminals were invading the home and maybe were trying to kill them. And Trina Martin, the petitioner in this case, and her partner both ran to the closet to get the gun that they kept there. Fortunately, they didn't have time to actually get it. I think the end result of this raid could have been much, much more serious. But once the raid team entered the bedroom, they pulled Trina and her partner out of the closet, dragged her partner onto the floor, shackled him, proceeded to interrogate him until one of the members of the team noticed a letter on the table that happened to have the address of the house, which did not match the address of the home that they were supposed to have raided. So they promptly left. They promised they would fix the door, which was lying, out on the front patio. They didn't. So consequently, the Martin family filed this lawsuit under the Federal Tort Claims Act, or the FTCA, which, among other things, allows citizens to sue the federal government when law enforcement officers like this commit certain torts like false imprisonment, battery, assault.
So this sounds pretty cut and dried. What was the controversy in the case, and what did the Supreme Court have to decide, and what did they decide?
Yeah, you would think it's cut and dry, but according to the lower courts, despite the clear wrong that occurred here, despite the innocent family whose rights were violated, the errors on behalf of the FBI agents, the court told the family that its claims would be thrown out and that there was no relief, no remedy here. And according to the courts, this was because any act that a law enforcement takes that is within his discretion is immunized. Any act that has a connection to a federal policy or objective also immunized. So, according to the courts, the FTCA essentially is a dead letter, and there was no
say that's a
relief.
lot of immunity.
Yeah. So that was essentially what the Supreme Court was asked to review here.
What did they ultimately decide?
So fortunately, the Supreme Court strongly disagreed with the lower courts. They essentially ruled that the FTCA means what it says, that there is a remedy, there is a path to relief for people whose rights are violated by federal law enforcement officers, and that you do have a cause of action against the federal government when something like this happens. Ultimately, the bottom line question in this case was, what do you do when your rights are violated by law enforcement officers? Is there a remedy? And according to the lower courts, the answer was no. You could be seriously, egregiously harmed, but there's nothing we can do for you. Sorry. But as I said, the Supreme Court made it clear that that is not the correct interpretation of the law or the Constitution, and they have restored the Martin family's lawsuit.
Well, this is good news for anyone who's a victim of a wrong house raid, but does this impact other qualified immunity cases if the police have done something else within their discretion that violates someone's rights?
I don't know that it has directly impacted, qualified immunity and the other millions of forms of immunity that exist today, but I think it is a step in the right direction, and it at least signals to us that the Supreme Court is thinking about these things and is cognizant of the fact that it is exceedingly hard for an individual whose rights are violated by the government in whatever capacity to find a pathway to relief. So we do know now that there is at least one.
And if Congress creates a cause of action, as it did back in the 1970s, the Supreme Court will uphold the ability to sue in that case.
Exactly.
Yeah. Casey, thank you for explaining the Martin case to our audience. That was very helpful.
I'm glad to be here.
John, McLaughlin Chiropractic Associates v. McKesson, what was going on in this case at the Supreme Court?
Well, this case has two things in it that are near and dear to my heart: obsolete technology and class actions. And what the court was interested in, however, was whether or not you get to go to district court and whether the district court has to listen to the administrative agency, in this case, the FCC. And what happened here is there was an old law, you can tell by what it says, it's the Telecommunications Consumers Protection Act, that said that if you send facsimiles, faxes to people without a way for them to call and cancel getting any further faxes, every fax after that you pay $500 minimum on. So there were class actions saying you sent all these faxes to us and you didn't tell us how we could get them to stop. And McKesson was sending these out to chiropractors everywhere. So there was a big class action with millions of these things. But because of the obsolete technology, there were only 12 that actually came in paper. Went dit. And the FCC stepped in and said, well, we think the act means just those paper faxes and not when they come to you now by email, even though they say facsimile. So that was the issue. And the important point for us, I think, Mark, for administrative law, is that the court broke up statutes into three kinds. One statute says no district court jurisdiction. All right? That's out. One statute says yes.
That's sort of a jurisdiction stripping explicitly.
Correct.
Kind of
and they say you
situation.
can't do this. The other one is when they say you can do it. But the third is when it's when you don't know, because this involved the Hobbs Act, which says that the agencies can't be countermanded. Let's just put it that way. And so, but it doesn't say that they don't have jurisdiction and they can't make normal rulings as they normally would. And what Kavanaugh and the majority said is, well, the default rule under Loper-Bright cite is that they do not defer. And so the court has to give its best reading of this statute. And so they remanded it for that purpose, which obviously is worth a lot of money, because the way this statute works is it's $500 per fax. There were millions of faxes. And if they found out you did it willfully, treble damages.
Oh.
So there was a lot of money involved. But the fact of the matter is, this had the change of technology. It had what the law meant. There were a lot of things going on there. But the key takeaway for the administrative state is that on all these statutes where it doesn't explicitly say, like some of the environmental statutes say, the district court can't get involved, that and here the district courts will have that power.
And so why should folks outside of the TCPA context care about this case?
Well, they should care because what's the problem? The problem is that the administrative agencies, sometimes they're captured, right? The FCC doesn't really care about chiropractic doctors, do they? They care about how the telecommunications companies are going to do and whether or not the products are going to be used. That's who runs the FCC. That's their mission. So they may have a capture by that group, and you don't get a fair hearing on what the law is.
So you want to get to district court.
You want to get to district court because then, at least, as we've said in Loper-Bright, we see at least you have a fair adjudication. What does this law mean without the administrative agency thinking, well, what do I want? And what's good for my agency and who we regulate? So I think that this will happen in many agencies. This could happen. This could happen with Interior. This could happen with a lot of folks. But now they don't have to do a big fight over whether or not they can get to district court and whether district court can rule. And that can affect a lot of people.
Yeah, as we saw in the Cochran case. Well, thank you for being here to explain that to the audience, John. That sounds like an important decision from the Supreme Court. It will have a big effect on everyone.
I think it will. Thanks for having me.
So, Cara, Diamond Alternative Energy v. EPA, what was going on in the background of this recent Supreme Court case?
At its core, this is a Clean Air Act case. And what it's really looking at is whether or not waivers given to the state of California to have heightened regulations are permissible. But what was before the court specifically was a question of standing.
And so then what was the specific issue that the court was asked to decide, and what did it hold in this case?
So standing is always a threshold question for courts, right? This is the cases and controversies part of the Constitution. It's a limitation on what courts can do. And at an irreducible constitutional minimum of how we typically refer to standings elements, we talk about injury, causation, and redressibility.
And you have to have all three of those things for standing.
Have to have all three. And the courts have routinely said, for example, that the causation and redressibility are two sides of the same coin. And they're really to sort of check that the injury kind of carries through all the way to the remedy that's ultimately granted against the other party. This case is about the redressibility element of standing.
And so what did the court decide about redressibility here?
So this group of liquid gas producers came forward challenging the waiver that was given to California to adopt this regulation, which was also ultimately adopted by 17 other states. So you can see that across the country, there's potentially significant depression of purchase of liquefied gas as a result of encouraging use of electronic vehicles. And what the court said is, even in instances where the regulation is really specific to the producers of vehicles, there are sometimes secondary effects, and those businesses that are affected even in a secondary manner have standing to challenge. And that's really important in a system like ours where regulations don't occur in a vacuum.
Yeah, absolutely. And so why should people outside of this, this case sounds like it's between different kinds of fuel producers who want to sell cars in California. Why should anybody else care about the holding in this case?
This is really about, at the end of the day, opening the court doors, or maybe more importantly, keeping the court doors from being closed in scenarios where one party is injured but maybe is not directly regulated. And that's particularly true when there's economic interest involved. It only takes $1 of injury, right? So even if $1 less of gas was sold as a result of these regulations, that's enough under existing standing to allow those court doors to remain open to bring the challenge.
Well, that does sound really important and interesting, and thank you for being on the program to explain what happened in this case to our audience.
Thank you for having me.
Now that we've had a chance to discuss all of these cases individually, I'd like to have a quick discussion. I think there's a theme that runs through these cases, and I think the Supreme Court might think that as well, because 3 of your cases were released on the same day, June 20th. And it feels like in each one of these cases, the Supreme Court made it somewhat easier to sue the government. Andy, would that be true in your case? Do you see it that way?
I think that's right. Certainly in our case, the court kept the Supreme Court kept the courthouse doors open to many people across the spectrum to challenge a lot of agencies if those people think the agencies made a decision that's wrong.
And how about your case,
And for
John? So this was RJ Reynolds' vapor, and your case is
McLaughlin.
McLaughlin,
And
yeah.
in that case, it basically took a whole swath of statutes. We don't even know the number of them, because until you get into litigation, there's no list of cases where they don't say whether or not the district courts are out or in. And this is that third tranche where Congress hasn't said anything about it. But they're not going to be using the Hobbs Act to keep everyone out of court.
Well, they didn't have your amicus brief in his case with the 124 statutes that were affected by.
That's right.
Well,
They-
what was
they
going
could
on?
use that help.
Right. So, but the fact is, it's going to be widespread, because there's going to be a lot of statutes like that, and you're going to be able to get a fair ruling from a district court and not by an interested agency.
And what about Diamond Alternative Energy? Do we have the same sort of effect there, do you think, Cara?
Yeah, and I think one of the critical things that happened there is that the losing side, EPA and the state governments, actually pushed for a heightened evidentiary standard for redressibility. They essentially wanted them to put in affidavits and declarations from third parties saying, yes, we will actually change our behavior as a result of that. And the court squarely rejected that. And more importantly, they sort of rejected it in part on the theory that you're never going to be able to get that, right? They started to give away this idea that we talk about all the time. It is really hard to get people to go against their regulator. So do you think somebody's really going to sign a third-party affidavit in a case that they're not involved in to say, yes, we would change our behavior if we stopped being regulated in this way? It was an absurd premise. The court rejected it, and I think that sort of pushes back on the administrative state in the future from trying to make these really just out there arguments.
And then, Casey, your case came down on June 12th, so it wasn't part of these, and it didn't directly involve a federal administrative agency. It was more the Department of Justice, I guess, or an FBI. But it seemed like it might have had somewhat the same kind of result.
I think it's similar, but not quite the same, in that I think the courts made it as easy to sue the government as Congress said it should be. In Martin v. U.S., the FTCA is a congressionally enacted pathway to recovery. It's a cause of action when federal officers commit certain torts. And what we saw in that case is the courts, the lower courts at least, had reinterpreted or rewritten a layer of immunity in the act that Congress never did. So in a way, it is similar to these cases as well.
Yeah. So, final thoughts on the term, at least regarding these 4 cases. Any takeaways for how this might affect other kinds of cases, either that we have or that the other folks might have?
Well, one other part of the RJ Reynolds case that's helpful, that's a good sign, is that not only did the court keep the courthouse doors open, but it did it by taking plain English, which said any person adversely affected, and giving it its plain meaning, and pushing back on the government's effort to kind of change that meaning
And narrow it.
and narrow it to protect the government from challenges. So that helps predictability going forward, and it's easier just to tell what the law says. So that's a very good sign.
Yeah.
And I'll just say, for McLaughlin Chiropractors versus McKesson, Kavanaugh says Loper-Bright's the default rule. And so there has been some concern and some push, I think, by both the government and certain commentators to say, oh, Loper-Bright is not going to be that big a deal.
Right. Didn't mean anything.
Didn't mean anything. That is out the window if the Supreme Court is routinely calling it the default rule that should be referred to first before you do anything else. So I think it was very good for that reason.
And I think it's interesting to reference Loper-Bright because one of the comments we heard regularly after last term was that was the administrative law term, right? You had Loper-Bright, you had Jarkissi, you had all these big cases. What the outcome here is a lot more subtle, in terms of the more people that can get into court and stay in court, that has its own sort of effect over time.
Which we saw from our Cochran case a couple terms ago.
Exactly. And so I think that, if it leads to more challenges to government action and more people can bring cases and they're enabled to bring cases and they're not getting kicked out at these preliminary stages, one that holds accountability in place for the administrative state, which is something that we at NCLA are always interested in, but it allows more arguments to happen, more cases to percolate. It means more of these things make their way up to the Supreme Court, and I think that that allows opportunities going forward. But I think that that sort of impact is going to be a lot more subtle than, say, a Loper Bright or a Jarkissi was, last year.
And then what about your RCAF case? Do you think there's going to be an impact here?
Yeah. I mean, so we have a case where the USDA has decided in its infinite wisdom to tag all cattle under certain requirements with radio frequency ID tags. It costs about $4 per cattle. We're talking multi-million dollar rule. And again, as we talked about, agency loves kicking out cases on standing. They said, well, you're not really harmed by this rule. Your producers, your cattle guys don't have standing. If they're standing in RJ Reynolds, if they're standing in Diamond, if there's, McKesson, then they're standing here for people that are physically paying to put a tag on a cow. And so I think that, maybe I would be hopeful that we're going to see less standing challenges come out of DOJ as a result of this, but that would remain to be seen.
Less winning. They'll still make them.
They'll still make them. They have a checklist they have to follow.
Yeah, that's right. They wouldn't know what to do without that template, right? And what do you think, Casey? I know we talked earlier about the fact that this may not have an effect on other qualified immunity cases, but surely the court is sending a message to the lower courts: stop inventing these doctrines that are trying to keep people out of court.
Exactly. I think it definitely signals that the Supreme Court is drawing a line in the sand. And if it had ruled the other way, if it had gone with the lower court's interpretation or misinterpretation of the FTCA, I think it would have been a step even further and worse than qualified immunity, which is a judge-made doctrine. Because here we're talking about actually a congressionally enacted statute. And if judges are allowed to just interpret in immunity that was never there, and that in fact the act was meant to remove, that's a really serious problem. I mean, qualified immunity is already horrendous, but so I think at minimum it's a relief that the court ruled in this way, and I'm hoping that it is a signal that they might start to be thinking about qualified immunity and all these other layers that are protecting government officials who are even the worst of actors.
I hope you're right. We're going to continue to come after qualified immunity, and I do think it's going to have an effect on RCAF, maybe some of our other cases. We have a case pending in the Sixth Circuit where we were denied standing in going after the last administration's attempts to unlawfully forgive student loan debt. And I think, much as you said about RCAF, given the holding in the RJ Reynolds case, given the holding in the McLaughlin Chiropractic case, I find it, and Diamond Energy for that matter, I find it hard to imagine that there wouldn't be standing for our client in the student loan debt forgiveness case. We'll find out how these cases apply in the lower courts, but I think we'll see that these cases may not be the ones that are the most talked about this term, but they're going to have quite a dramatic impact on the administrative state and people's ability to get into court. Well, that was a terrific discussion. Thank you for participating in this conversation about these cases at the Supreme Court this term, and thank you for tuning in to Courtside Commentary. We'll see you next time.